Hello, we're here with Michael Ryan, who is running for Superior Court Judge, position number 37. If you'd like to take 2 minutes to introduce yourself.
Great. Hi, I'm Mike Ryan, and I'm running for Department 37 on King County Superior Court. I was appointed by Governor Inslee in January of this year, and I've been on the bench now for about a little over 3 months. I don't come from a family of lawyers. Neither of my parents went to college. My dad was a union electrician, and my mom stayed at home with us when we were younger, and then she worked as an assistant in an accounting office, a solo accounting office. And so the thought of being a lawyer or a judge when I was a kid, it wasn't really in the cards for me, but my parents taught me early on the value of hard work and fairness. And I think that the lessons that they taught me as a kid, that if I work hard, study hard, get an education, that there are opportunities for me. And I think my parents instilled those values in me. When I moved to Seattle, I worked for a large law firm called Preston Gates & Ellis, and I ultimately became a partner at the law firm of K&L Gates, one of the largest firms in the world. And I left there about 3.5 years ago, 4 years ago now, to basically go into public service. I went to the Seattle City Attorney's Office. And when I was there, I worked on a lot of fascinating issues. And one of the issues that I'm most proud of working on was defending the rule of law against the Trump administration's attempt to strip the city of its federal funding for its so-called sanctuary city status. It was a very proud moment the day that the court ruled in our favor, and I was proud to be a part of that team upholding the rule of law against the Trump administration's decision to try to strip the city of federal funds. Thank you.
Thank you. And now we'll go around the room. I don't remember where we left off last, so we'll start with Elizabeth Campbell.
Okay. How would you describe your judicial philosophy?
Well, I think the judicial philosophy that I try to bring to the bench every day is I want to make sure that the individuals in front of me feel heard, that I treat everyone fairly and equally and with dignity and respect. It's important to me to explain my rulings when I make them and try to explain them in terms that people understand. So my ultimate philosophy is that everyone who comes into my courtroom is going to be heard, is going to hopefully feel that they've been heard, and when they leave the courtroom, is going to understand why I made the decisions that I made. I think it's really important for a judge to be able to explain their decisions to the parties before them. Not everyone who appears in my courtroom is a lawyer, and so I think in a lot of ways, a judge is the face of the judiciary, and maybe in a lot of situations, the only experience that an individual ever has with the court system is the time that they are in front of me. And so my philosophy is that everyone understands what I've done and why I've done it. I think that ultimately that fosters respect for the judicial branch. And I think it also allows people to, if they leave feeling heard, and even if they don't win, I think at least they understand that the process itself was fair. And I think to a judge, the process of how things go is an extremely important part of the job that I do. So that's basically my judicial philosophy.
Let's move around this way to Sherry.
In the area of hate crimes, what are some of the issues in balancing speech rights against the need to control offensive activity?
Yeah, I think the issue of hate crimes is, I spent a lot of years both in private practice and also when I was with the city of Seattle. I did a lot of First Amendment work. So I'm very familiar with all of the First Amendment cases that deal with hate speech. And I think one thing to think about, one of the issues that come up is someone exercising their free speech rights that may be very offensive to some individuals. The U.S. Supreme Court has made several rulings where they've allowed people to say very offensive things at funerals, for example, or to burn an American flag, which a lot of people are offended by. Another issue is not every time that someone is engaging in that behavior, they necessarily even engaging in speech, because there's a difference between speech and conduct. So it may be inappropriate, for example, in sentencing, to consider someone's motivation for doing a particular crime. That may be a factor that can be considered in sentencing someone, but you do, as a judge, you do have to balance those rights, the rights of everyone to feel welcome and to feel that they can be who they want to be, and not have people say things about them that are hurtful and mean. But on the other hand, you have to balance the protections that the First Amendment afford individuals to say things that are, many might believe, to be truly distasteful. And so I think it does raise a lot of really interesting issues that courts often have to face. As a trial court judge, the Supreme Court has said what the law is, I'm bound to follow that. So I think that's some of the issues that you see with hate speech.
How would you deal with the pro se party appearing in your court?
I think pro ses need to be treated with dignity and respect. I think if you treat them on equal footing with the lawyers, you can set a good balance in your courtroom. Now, having said that, in my litigation life, I've had pro ses on the other side of my cases. And it is oftentimes very difficult to deal with pro ses because they don't understand the process necessarily. They're not trained in the process. And the process to get into court, to present an argument in court, it's not necessarily that intuitive. And so I think with pro ses, you have to allow them to speak. You have to allow them to feel like they've been heard. But the appellate courts have been clear too that you can't necessarily assist them. As a judge, I can't sit up there and provide legal advice to a pro se. I can't take a side in a case. Now, having said that, the same rules maybe of decorum and of presentation that you would apply to trained attorneys wouldn't necessarily apply to pro ses. I think you want to give them a little more leeway. Is that the ice cream truck? Sorry. And so I think that there is a balance that you have to strike with pro ses, where you give them the opportunity to be heard, so long as they're not being disruptive of the proceedings. And some people decide to be pro se because they want to be pro se, and others because they simply can't afford a lawyer. So I think you have to be cognizant of that as a judge.
Thank you. Yeah.
What is your favorite flavor of ice cream? I'm sorry, number 4.
I was going to go with fish food by Ben & Jerry's.
It's like the rest of government, the courts have struggled with reductions in funding. Where can courts cut costs and increase efficiency, and how will you advocate for sufficient funding of our judicial branch?
Sure, I'll take the first part second. I think that the courts should be fully funded, and I think that should come from the general revenues. I mean, the courts now are kind of forced to, in some ways, raise revenue by filing fees, by requiring people to pay for access to public documents and court files. So I think the best way to have a fully funded court is to have those who set the budgets fully fund the court, and the court needs to have a dialogue with the county, to some extent the state, to what its funding needs are, and needs to be able to explain why they need those funds, work that the court does, especially in the Superior Court, is quite varied. And there are, we see it all the time where we could use more commissioners, we could use more pro tems, and we could use more help on a lot of issues, and we simply don't often have the resources to do that. Now, with respect to the first question, in terms of what are some of the ways to kind of cut costs or manage costs better, King County Superior Court right now is a very paper-heavy court. We have technology, we have capability, and that obviously is a front-end cost that you have to put in to manage documents electronically. And I think that's one way to save money, is to reduce the use of those types of resources. And I think that dovetails into also allowing people to have better access to these documents, because if you can get to something online very quickly, you shouldn't necessarily have to pay for a paper copy of that document. So I think that's some of the ways the court could save money.
We have time for follow-up questions, so I see Elizabeth.
So you sit on the bench in South Kent, in Kent, and I'm general here, but you see perhaps a larger, more vulnerable population that comes through the courtroom than you would maybe in another part of the county. I'm wondering if just your short 3 months so far in Kent has impacted or affected or helped to grow in some way your philosophy from the bench.
Yeah, I think, like I said, the work that the Superior Court does is so varied. On any given day, I might have a criminal matter where a defendant is coming in. I may do a plea in the morning, and then I may do something with respect to the Involuntary Treatment Act and the courts, the mental health courts. And it's very, I think, for me, it's very humanizing to go into a courtroom and see all of the issues that come in front of you. Because everyone has a story on how they got to that place. And I think what it's taught me early on is that there's a value in listening. There's a value in trying to understand perhaps why someone is in the position they are in, because that's going to ultimately better inform the decisions that I make. And I do, it has been an experience to be down in Kent. I use, for example, the jury pools that we get. When 50 people come in, the diversity on that jury is much different than it is in Seattle. And I think that it's very enlightening to listen to a jury during voir dire when they are being asked questions and explaining. So those are some of the things that have kind of made me focus and shift a little bit in my thinking.
Any more questions?
Different states choose their judges and retain their judges in different ways. Do you like the election process that we have, or do you think we should have just a pure appointment, maybe an appointment and retention process like some states do?
Yeah, obviously the states have a right to order their chairs how they rule. I mean, the federal courts, it's a lifetime appointment. And there are some benefits to that and some drawbacks to that. California, I think, has a system where if you're appointed, it's simply an up or down vote, retain or no. And then if you don't get retained, then there's an election. But I think the way Washington has organized itself, it's ultimately good that the people are getting to see judges, and the judges are out there in the public more because of it. Not only when you're running for election or retention, but when you realize that you are part of the community, because ultimately the voters are the ones who are responsible whether they want to keep you or not. And so that gives you, I think, a sense of an obligation to want to be more out in the public. I think it's an appropriate place for judges to be out in the public, meeting with people. It may not be appropriate for them to talk about the cases that they're working on, but I think all in all, it's beneficial that judges have to be more out in the public. that's fostered by Washington's system.
Great. Anything else?
Could you comment on Charlottesville, as an exercise in free speech, parts of people who
I'm trying to figure out the best way to answer that without, I think that it's hard for me to figure out which parts of Charlottesville you may be talking about. I mean, there are the rallies and the protests and then the counter protests.
I wasn't talking about the town or the university,
No.
I was talking about the demonstrations.
And I understand.
2 years ago.
Right, and I think that, that is a situation where there were individuals who were exercising First Amendment rights, and it goes back to the hate speech question from earlier. And then you had a situation with counter protesters, and in some ways, in that situation, it's really a function of crowd management by the police to try to keep these groups separate and allow everyone to have whatever their message is there. It's an obvious tragedy what occurred in Charlottesville, and probably could have been avoided. But again, you have to balance those free speech rights. Sorry.
I have a fun one, or maybe not that fun. Can you describe your most difficult case?
Gosh, I probably describe my most difficult case as a lawyer. And so I think some of the issues I worked on were really, particularly at the city attorney's office, were very interesting work that I did. In terms of a difficult case, I would give the examples when I was defending a city law. It was the first of its kind law in the country, where it was going to allow Uber and Lyft drivers to unionize. And it was challenged by the U.S. Chamber of Commerce, and one of the biggest law firms in the United States. And it was challenging to me because in order to successfully defend the laws we did in the district court, and then it was remanded back after a Ninth Circuit argument, I had to learn antitrust law and labor law almost overnight. And those are not issues that I had litigated before, I had really thought much about. So it was a difficult case in the sense that it required me to learn a lot of new areas of the law.
Any other questions? Seeing that, Jeff has one more?
If we have.
Yeah, we do.
So Ben and Jerry's was not available.
It's
I was wondering
good tomorrow.
if you have a Supreme Court justice in the U.S. or otherwise, past or present, that you look to as a hero, or their judicial leadership is example to them.
Sure, I would say two, and I think that they have a relationship to one another. I have a picture of Justice Wiley Rutledge in my office that I got right after law school because I was inspired by a dissent that he had written in a case involving the Establishment Clause, and it was a very famous dissent that he had written. And another justice that listening to oral arguments and reading opinions is Justice Stevens, who happened to clerk for Justice Rutledge. Listening to transcripts of oral arguments in the way Justice Stevens is a consummate gentleman with the attorneys, a lawyer's lawyer, if you will, very respectful of the questions, but also when he would write an opinion, he was thorough, and he had conviction in his opinions. And I think that those are some of the qualities that I hope to emulate when I get on the bench. So those are some of the Supreme Court justices that have inspired me.
What is your position on a defendant's ability to pay court fees and fines?
Well, there's been a big movement, and particularly with respect to LFO's legal financial obligations. the way it is now, unless fees are mandatory, they're almost always going to be waived in a criminal case. Because there's really no point in shackling individuals with all of this debt, in addition to potential prison time, that they won't be able to get out from under when they return from prison. So to the extent that an individual is indigent, and he's demonstrated that, and it's not very hard if they're represented by a public defender, those fees are often waived. The court has to, more or less, the discretion or has to do it now. So I think that, simply tacking on all these additional monetary fees to a sentence, knowing that someone will likely not ever be able to pay these, but they become essentially a debt going forward, just doesn't make a lot of sense.
If you'd like to take about 30 seconds to wrap up.
Great. Well, first off, to everyone here, thank you for having me tonight. And to the voters, I would just ask for your support. I really, truly enjoy the work that I'm doing, and I want to continue to do it on behalf of the citizens of King County. It's an honor to be appointed by the governor, and I would hope that with your support, I can continue to serve in this role.
Thank you.